May it please the court, Isaac Gibson on behalf of the appellant, Ronald Matthew Lacy. With the court's permission, I'd like to reserve 5 minutes for rebuttal.
Very well, thank you.
Your Honors, this case concerns the outer limits of Tennessee's territorial jurisdiction. Despite Mr. Lacy never consummating a crime in the state of Tennessee, nor being present within its borders, Mr. Lacy was convicted by a Loudoun County jury of theft of property under Tennessee Code annotated Section 39-14-103. The undisputed facts in this case are straightforward and simple. He was never present in the state. He never obtained the alleged victim's property within the borders of the state of Tennessee. And Mr. Lacy did not reach into the state using statutorily defined means of an innocent or guilty agent or other means proceeding directly from his person within the meaning of Section 39-11-103. In order to establish territorial jurisdiction, Section 39-11-103 requires the state of Tennessee to prove beyond a reasonable doubt that the crime was consummated within the state of Tennessee. And if the defendant was not present in the state of Tennessee at the time of such consummation, that the defendant reached into the state using an agent or other means proceeding directly from his person to reach into the state in order to consummate the crime. Where conduct occurs completely outside of the state of Tennessee's borders, Tennessee cannot exercise territorial jurisdiction over the offense. Because no rational juror could conclude that the state of Tennessee proved beyond a reasonable doubt that it obtained territorial jurisdiction in this matter, we respectfully request this court reverse the Court of Criminal Appeals and enter a judgment of acquittal in favor of the appellant. I welcome the court's questions.
Could you, so there's a statutory definition of the word obtain that says obtain means to bring about a transfer or purported transfer of property or of a legally recognized interest in the property, whether to the defendant or another. How does your argument that the defendant did not kind of obtain anything in Tennessee square with that statutory definition of the term?
Your Honor, I would point the court to Court of Criminal Appeals decision in State v. Odom, which this court cited with approval, and in distinguishing the crime of theft from that of forgery, both this court and the Court of Criminal Appeals explicitly referenced receipt as a distinctive element of the crime of theft. And
Did those decisions discuss the statutory definition of obtain at all?
they did not.
I mean, isn't the statute what governs? I mean, we have to follow the statute, don't we?
You do, Your Honor, but respectfully, I don't think that the stretching of the statute that the state employs in this matter is what the court reached in Odom or in Lyons. It was facially that the crime of theft requires receipt of property.
Well, if you could, so I do want you to actually talk about the statutory definition and explain how, in light of that, you know, if we have to follow the statute, so in light of that statutory definition, just explain your position that your client did not actually obtain property in Tennessee.
Well, our position...
Again, I want you to talk about the definition and
yes,
not the
Your
case
Honor.
law.
Yeah, our position would be that the bringing about was not completed or perfected until the money, which is the property at issue in this case, was received by the defendant. It was not fully brought about until the money entered his bank account or his constructive possession.
So your position then is that there could never be a prosecution such as this in Tennessee unless the payment was physically made in Tennessee?
Not necessarily. When you said
Well,
the
then
payment,
what else could it have? I mean, if you say the receipt of property had to be within the state of Tennessee for that consummation to have taken place and it to comply with the statute, how other way could you comply with the statute other than for the actual receipt of the money to take place in Tennessee under your interpretation?
well, under our definition of the statute as far as theft goes, then yeah, it could not be consummated within Tennessee unless the defendant exercised control or obtained the property within the state of Tennessee's borders. It certainly could be prosecuted under a crime such as attempt, and I think that the state's definition that it asserts in this case is much more akin to an attempted theft, where a substantial portion of the crime may or may not have been brought about but the actual obtainment and receipt of the property is not required according to the state.
Well, what if the defendant had a bank account in Tennessee? And so the transfer happened and the money was deposited into the defendant's bank account in Tennessee. Would that be enough, even if the defendant was not physically present here?
It would certainly be different. I mean, I guess under that hypothetical, the discussion will be centered on whether he possessed it upon the moment it was in his bank account, and whether he had access to that account at the time.
So in your view, it turns on whether the defendant actually was exercising control over
Not necessarily.
the property?
I mean, that is included in the statutory definition. It's obtain or exercise control over the property of another with the intent to deprive, I believe is the theft statute. Our definition is that obtain and exercise control requires at least some sort of constructive receipt at minimum, and in this case, that couldn't have happened in Tennessee.
Well, let's take Justice Campbell's hypothetical a little further then. Let's assume that your client has a bank account in the state of Tennessee. The money goes into the bank account in the state of Tennessee, and it sits there for 2 weeks. So the bank can't possibly put a hold on it. Funds are good, everything's good. Isn't at that point your client in control and therefore subject to the jurisdiction of the state of Tennessee?
Under that hypothetical, I think arguably he would be because of the...
Arguably or yes? What's the caveat?
I don't think there is one necessarily. I mean, if the bank account is in Tennessee, then I guess the location of that bank account that is subject to the control or access of the defendant, then I think that would vest jurisdiction in Tennessee under that hypothetical. But in this case, the bank account's not in Tennessee.
Well, let's assume for a minute the bank account was in the state of Washington. Would the prosecution have to be in the state of Washington for theft under these circumstances?
I think if the theft was consummated in Washington, if that's the hypothetical as I understand it, that because the bank account's in Washington, theft is consummated in Washington, then presumably that would be, jurisdiction would be proper in Washington. But I also think that federal laws of interstate mail fraud, interstate wire fraud, and the like would vest jurisdiction in the federal court.
What about if it's a financial institution that exists on the internet and the account is in the cloud? What do we do then?
I don't have a great answer for that, Your Honor. I apologize.
And yet I am asking you, aren't I?
Well, if it's in the cloud, then I think that the most workable factor would be the location of the defendant. I mean, that's kind of the traditional understanding of territorial jurisdiction.
How would that affect consummation of the crime if it goes to the logical limits of what you're arguing? Doesn't it make sense to say that the crime is consummated when the victim, who here is in Tennessee, presses send and sends it to the defendant?
Well, not necessarily, because that did not vest, the defendant didn't obtain the property at the moment that the victim pressed send. It went into the cloud.
How many nanoseconds did it take?
I'm not sure. I'm not sure.
Interim?
My recollection of the record, I don't know if there's a hold on the account for a couple days.
I mean, we have to grapple with the way transactions are done now. And so we can't necessarily tag it to where the defendant is physically sitting, but we can know where the victim was here. We know the victim was in Tennessee, and the victim pressed send, and it sent the money to him.
Yes, Your Honor. But I think that interpretation is broader than Tennessee's territorial jurisdiction statute contemplates. It's tightly tethered to the consummation of the crime. The other statutes in some of the sister states that the state references are much broader. Some of them even explicitly encompass this effects doctrine that the state alleges this court has adopted. Tennessee's statute doesn't do that. It simply requires consummation of the crime within its borders. And strictly construing the theft statute, the consummation did not occur until the element of receipt was affected, and that did not happen within the borders of Tennessee.
So, Mr. Gibson, when the money's in Tennessee, the defendant's in Tennessee, the money leaves Tennessee, and the position is there's no territorial jurisdiction here until the money is received elsewhere. That's what you're saying, but isn't the victim violated in Tennessee when the money leaves his account?
Yes, Your Honor, but our position as it relates to the statute is not concerned with the victim's harm or the effect of the crime as these other statutes are. It is explicitly related to the actions of the defendant, the consummation of a crime, the harm or the result, like Your Honor just discussed, that may or may not have occurred in Tennessee is not, it's our position it's not encompassed in Tennessee statute. It is explicitly contemplated, and even the words such as result and effect are used in some of the other states on which these persuasive opinions are based on statutes that are just broader, that contemplate an effect or a result that's not necessarily narrowly tailored to the elements of a crime.
So let me ask a follow-up, if I might. Let's say that we're not talking about money, that we're talking about a cow, okay? And there's a guy in Kentucky that wants this Tennessee cow. And so he goes and he hires somebody to go steal that cow and bring it back to him in Kentucky. Okay. Now, am I to understand your argument that Tennessee would not have territorial jurisdiction over that case because the crime was not consummated until the cow was received in Kentucky?
So under that hypothetical, you're saying a defendant in Kentucky hires an agent to effectuate a crime of stealing a cow in the state of Tennessee.
Right, and the cow's received in another state.
I think under that hypothetical, there's a difference with the agent of the defendant, and it could be argued that the agent seizing possession in the state of Tennessee is an act of the defendant. And so under that hypothetical, the proactive use of the agent by the defendant, I think would distinguish it from our case.
If he had a lasso.
Our defendant didn't physically enter the state of Tennessee and seize the monies.
Well, counsel, you seem to be focusing on the consummation of the offense, correct?
Yes, Your Honor.
Okay, but well, you would agree that at least the commencement of the offense started in Tennessee, right?
Not necessarily in this case. I don't think that there was sufficient evidence that a rational juror could conclude that. That's our position. I would say that the state is resting its jurisdiction on consummation of the crime in its briefs.
If we disagree with you and find that the consummation took place in Tennessee, is that all she wrote? Does that
No, Your Honor.
mean ergo there's territorial jurisdiction?
We would point to the Court of Criminal Appeals and as well as the statute, and that if the defendant is not physically present in the state of Tennessee at the time of consummation, there is a defense if he did not use an agent or other means proceeding directly from his person. And so our position is that the electronic means at issue here were not contemplated by the General Assembly and are therefore outside of that statutory definition.
Outside of the statutory definition of what?
Of other means.
But how are electronic means not other means? I mean, how do you read
Our
other
position
means?
is, and as this court noted in State v. Legg, the language in the territorial jurisdiction statute is adopted from a 19th century statute from the state of Alabama. And our position is that the state has done, the General Assembly has done nothing to update that language to be all-encompassing. as the state asserts that it has. If anything.
But it used the word other means. I mean, isn't that a pretty broad, that's pretty broad language
it
that
is a
usually
pretty-
is intended to kind of capture anything else that is not specifically mentioned.
And it readopted the statute, and the state of Tennessee readopted the statute in 1989.
It did, Your Honor, and in 1989, the General Assembly did omit the word, I believe it's any other means, that was in the original statute. So our position would be, if anything, they limited it in 1989 by dropping the expansive word of any.
But that
other
was just a
means.
recodification, right?
Yeah.
I mean, it was a recodification. It wasn't, I mean, don't we generally presume that there was kind of no material change intended when it's just a recodification?
Well, it did, the original statute in the 19th century included the term any other means. And the statute as it was adopted again in 1989 does not have any, that's not present in the current
Okay,
iteration
how
of
does
the code.
that help you? Come on.
Our-
Because the question is whether electronic transfer is other means. Is it your position that the General Assembly, every time there's new technology, the General Assembly needs to amend the statute and list particular means? And they craft statutes like this with broad language to be able to capture changes as time elapses.
Well, I cannot find in my research and in the state submissions to this court as well, another case, other than this case that's almost contemporaneous to ours, Berkebile, where a court in Tennessee has expanded that language to mean something beyond physical means.
Okay, but that's why we're here today, to contemplate whether it should also encompass electronic means. The fact that there's been no case before now that interpreted it that way just accounts for why you are here. That's the question that's presented to us.
Well, my answer to that would be that there are numerous instances in the code where the General Assembly has intended to include electronic means, and it's done so explicitly. It's done so in the computer fraud statute, section 3914-602, the harassment statute, 3917-308, the statute prohibiting exploiting a minor via electronic means, section 39-13-529. That's just some of the instances where when the General Assembly has intended to include and encompass electronic means, it's done so explicitly.
Well, but there certainly would be a reason to specify electronic means if a statute is concerned specifically with some sort of electronic communication. I mean, that's a way to limit the means to which a particular statute applies. So, exploitation by electronic means, that's all you're intending to capture, is when it's done through electronic means. I mean, here, the legislature used other means, presumably, so that it is kind of all-encompassing and would apply to any other means, whether electronic or physical. So aren't those other statutes that you mentioned, I guess, distinguishable in that respect, that was used really to limit the application?
Possibly with a statute that is explicitly discussing a specific crime, such as exploiting a minor via electronic means. But, I mean, the harassment statute is something that's been updated to specifically incorporate electronic means within the definition of communications.
How do you read the language proceeding directly from the person? Do you think that, I mean, in what way does that limit the application of 2B?
I think that based on when the statute was adopted and the undisturbed nature of that language from the 19th century and the lack of any authority even extending it to some sort of contemporary technology like a telegraph or traditional mail, I think it has to be understood as physical means. And in State v. Johnson, the Court of Criminal Appeals immediate example that it notes, I think it's footnote 1, I could be wrong about that, I don't have it exactly in front of me, but the example they use is firing a gun across the state lines. So it's something physically coming directly from the defendant.
So if we go back to Justice Tarwater's Cal hypothetical, if the defendant were standing just across the border in Bristol and had a lasso and threw it across and took the cow, then that would be other means, physical means proceeding directly from the person.
I think that's a much more reasonable reading, considering when the statute was enacted and the way that our courts have interpreted it for the last century and a half.
Well, that sort of freezes the statute in time, I think, in a kind of unfairly narrow way. I mean, may have been the case that when the statute was originally enacted that, these were kind of the situations that would have applied, right? You would have had a gun, you would have had some sort of physical means, or you would have sent an agent to do the dirty work for you. If the means were not proceeding directly from the person. But, I mean, that's a really cramped way, I think, to look at the statute, given the language itself is, I think, sufficiently broad to include, these later developments and the way that crimes are carried out.
I would just respectfully disagree, and I would note that there's not been a court that's expanded it beyond physical means. I don't think the state or the appellant has submitted anything suggesting that Tennessee has interpreted this to include the telephone, traditional mail.
So you would really take the position that if a defendant sent a telegraph, this statute would not apply because telegraphs didn't, I guess I should clarify. I don't mean that telegraphs did not exist at the time that the statute was enacted, and so they can't be included. I'm just saying, at the time the statute was enacted, there's not been an interpretation that expands that language beyond physical means. Have there been cases that have expressly declined to expand it, or is it just that these situations have not yet percolated up?
I don't know the answer to that directly. I don't think, from my review of the record, there's a case that we've presented or that the state has presented that's declined to expand.
Well, isn't the fact that hasn't been decided why we're all here today?
Arguably so, Your Honor. I would agree with that. But I do think that the fact that not even a telephone call or something similar has been before the court, it's just not been expanded beyond the traditional physical means.
Well, I think you alluded earlier to the fact that there may be federal jurisdiction in a lot of things, a lot of these situations. So, in fact, isn't it likely that that's what's happened a lot of times is these matters have been prosecuted from a federal standpoint and therefore it's not allowed the development of the Tennessee case law?
That's certainly a possibility. I mean, I don't know that for sure, but I would imagine that there's been federal prosecutions of the sort of interstate conduct that we have here. If there's no other questions, I would request to reserve the remainder of my time for rebuttal.
Thank you, Mr. Gibson.
Thank you, Your Honor.
Thank you, Your Honor, and may it please the court, Matt Rice on behalf of the state. Mr. Lacy reached into Tennessee to trick a Tennessee resident into sending him money from Tennessee. Put simply, he stole money in Tennessee. And Tennessee courts have territorial jurisdiction over that theft because the crime was completed in this state and independently because the crime had detrimental effects in this state. And more than sufficient evidence suffices to support the jury's conclusion that Mr. Lacy stole money from Mr. Dyer. The court should affirm. I'd like to start where the court started, which is the bring about language. Section 103B1 confers territorial jurisdiction if the crime is consummated in this state, and we think there are two independent reasons that the theft here consummated in this state. One is the obtain, bring about language, and two is the effective consent, or more accurately, the lack of effective consent, which we think also was completed in the state. My friend gave no real explanation as to what the language bring about a transfer or purported transfer means if it requires receipt. There is no way to reconcile that language with the concept of receipt. The statutory definition of brings about means to cause to take place. And in our view, as soon as the victim hit the button that said transfer, a transfer had been brought about. It had been caused to take place. And if I can build off of the cow hypothetical, in our view, if you have a physical transaction and it's moving property from the state of Tennessee to the state of Kentucky, I think the natural language bring about a transfer would encompass the actual giving of the cow to the person who is moving the cow across state lines to Kentucky. I don't think anyone would say that at the moment Mr. Dyer hands over the cow to the courier to carry the cow to Kentucky, that a transfer has not been brought about until that cow is received in Kentucky. There was also a lot of discussion about how the defendant had not himself received the property. The statutory definition doesn't require the defendant to receive the property. It says the property can be transferred to the defendant or another, because the focus here is on the deprivation of the property from the victim. It is not on the receipt of the property from the perpetrator. And I think that interpretation not only gives meaning to the plain text, it resolves the problems that Justice Kirby rose, which was with respect to this bank that is in the cloud. That problem doesn't exist under our reading of the statute, because as soon as you hit the wire button,
So
you
what
have
if
brought about.
What if the defendant never obtains control of the money?
I think
It goes to a wrong bank account, something like that, where the victim is, the money is out of the victim's hands, but the defendant also doesn't receive it.
we still think, Your Honor, that falls within the statutory definition, because obtain is defined to mean bring about a transfer or purported transfer of property, whether to the defendant or another. So in that circumstance, the property would have been obtained if there was a wrong routing number or whatnot. It would have been obtained by another, but there still has been a transfer of property.
Mr. Rice, does the fact that in 2A, an innocent or guilty agent, the use of an innocent or guilty agent is sort of another means to establish territorial jurisdiction, does that lend some credence to opposing counsel's view that the other means must be physical? I mean, if other means were, couldn't the legislature have just drafted the statute to say, any means, if the defendant used any means? So, I mean, I guess this proceeding directly from the person language makes that a bit odd. But, I mean, if a defendant uses an agent to accomplish his goal, that is certainly, I guess, using means to accomplish, using some other means to accomplish the crime.
Yeah, we think the plain language of other means is very broad. Certainly the fact that you have an agent or some other, I guess, physical being listed first in that list could lead, I guess, to an inference that somehow other means is somehow limited to physical means. But I think that inference is at odds with the plain text, which includes any other means distinct from the agent itself. And, Your Honor, I guess there's been a lot of reference to the history of the statute. I mean, the statute was updated in 1989. In 1989, there were electronic forms of communication. There were phones, there were telegrams. So this notion that this is from the 1840s when there was only physical means, I think that's reading a lot of history to kind of create an atextual limitation that is found nowhere in the text. I do want to make sure I situate this conversation, this colloquy, Your Honor, which is that if we're talking about 103B2 and the other means, we've already concluded that there has been a crime that is consummated within the state, and we're only asking whether this falls within the it is no defense provision. Of course, we have argued that the it is no defense provision does not itself create any affirmative defense. We think we squarely fall within that.
Yeah, let me ask you about that. So, you point to some other statutes that have this it is no defense language, I think, to support your argument that, you shouldn't, that this doesn't create, by implication, that a defense would apply in other situations. But I think, something that's unique about this provision is that it has this if clause at the end that specifies the conditions in which it will be no defense. So doesn't the inclusion of that if clause lead to a stronger, I guess, implication that if those conditions are not met, that it would be a defense in other situations?
I think it leads to a stronger implication, but not strong enough, Your Honor. And the reason I say that is because the plain text itself, I think everyone agrees, does not create a defense. It says it is no defense. So you have to imply or infer the existence of the defense. I take the point that the if language could perhaps provide or lend more credence to the inference being drawn, but I still think that the court would need to be really careful about creating that inference of a defense, because in 39-11-204, the General Assembly has been very specific that says when we want to create defenses, we use this specific language. We say it is a defense that. It would not have been hard to use that language here. You could say it was a defense that the person was outside of the state when the crime was consummated unless A or B. That's not what the legislature did, and we think it's important that this 1989 enactment, so this it is no defense provision, came from 1989 when the statute was updated. It was literally the same exact public act that was used to add the instruction that we only create an affirmative defense when we use this specific language. I think it's really odd to suggest that the legislature was clarifying to the courts, please stop inferring defenses when we don't create them unless we use this language, and then later on in that same act use it is no defense to somehow create a defense.
How do you read well, and just one follow-up question about that. I mean, we don't really need to decide that question here about, whether these are the only defenses when the defendant is outside the state, or whether it could be broader, right? I mean, your position is that one of the conditions at least is satisfied here, so we don't need to address that.
I think the cleanest way to resolve this case is to say that the crime consummated in Tennessee under 103B1, and whatever the scope of 103B2's, it is no defense provision. Here, the facts fall squarely within the other means, agent or other means language. That's, I think, the cleanest way to resolve it. I'm glad to leave for another day this fight over whether 103B2 creates a defense at all. I do think, though, the court should, and I know we haven't talked about it today that much, and I don't necessarily think the court has to go to the common law doctrine because we fall squarely within the scope of the statute. But I would caution the court to potentially at least leave that issue open, because there are a number of offenses in Tennessee law, bribery that happens out of state and has detrimental in-state effects, failure to pay child support. There are a number of offenses in which the common law doctrine may be important. It is not important here today because we fall within the scope of the statute, but I want to make sure that I get that point out there, because in a future case that common law doctrine may be very important.
Mr. Rice, let me ask a point of clarification. Is it correct that the state, even at trial or here, is not relying on subsection C, which flips the issue of commencement and consummation?
Well, Your Honor, I don't know that it's true that we're not relying on it. We think this is a clean consummation case. The jury was instructed to decide whether it either commenced or consummated. So,
so the jury was instructed under both scenarios?
Under both circumstances.
Okay.
And so, Your Honor, I don't think there's anything that forecloses the commencement in the state. I mean, fundamentally, our view is that all three elements were satisfied at the moment that Mr. Dyer hit the wire button, and that two of those elements were satisfied in Tennessee. We've already discussed the obtain element and giving effect to the language, bring about a transfer. We also think the effective consent element, that turns, I'm sorry, Your Honor.
Let me go back to the obtain element that you just mentioned, because you cite 3911, 106A, 27, blah, 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 that obtain means to bring about a transfer of property to the defendant. And I'm looking at page 29 of your brief, quoting the statutory language. Does the addition of the phrase to the defendant mean that the defendant has to receive it in Tennessee?
Yeah, I don't think so, Your Honor. One, because the statutory language goes on and it says "or to another." I didn't include that because this wasn't, the money wasn't transferred to another. But we do think the defendant "or to another" highlights that the statute.
I can see that if it was, transferred to a cutout or something like that. But I'm focusing more on where the crime was consummated, and if the obtainment is statutorily defined as bringing about a transfer of property to the defendant, and there wasn't any other agent or anything like that here. We just have one defendant. Does that mean that it was consummated outside of Tennessee?
Not under our read, Your Honor. We think that the bring about language doesn't require a receipt. If I can try to use a perhaps slightly different scenario to try to illustrate the point. If I order something from Amazon, and Amazon ships it out, I think everyone would agree that I've brought about a shipment to myself, right? But I think everyone would also agree that at the moment Amazon sends that package, I've brought about that shipment to myself, whether I receive that package or not. That package may go to my neighbor's front door. My receipt doesn't dictate whether you have actually brought about the shipment itself. That's how we're reading the statute, and that's what we think happened here. That's why we think when he pushed the button, he had brought about a transfer to the defendant before the defendant ever received the property.
When the victim pressed send,
Yes, Your Honor.
that was bringing about the transfer to
Yes, Your
the
Honor.
defendant.
Let me
Okay.
follow up on my previous question regarding Section C and the jury instructions on that. Did the jury return a jury verdict form that specifically made findings on both of those, or was it a general verdict?
It was a general verdict, Your Honor. Yes, Your Honor.
Mr. Rice, I want to go back to, I guess, 3911, 103, 2B, the other means proceeding directly from the person. I don't think there's an argument here by the defendant that these means did not proceed directly from the person, but I am curious about how you read that language, just as we're thinking about, how this might apply in other cases. How does that proceeding directly from the person language limit the application of this provision? Do you have any examples of, I guess, when that might, provide that there isn't territorial jurisdiction?
Yeah, and this may be overlap with the innocent or guilty agent, but I was thinking, as I was preparing, thinking about like distribution chains, for example, like if someone has sold fentanyl in California, somehow it makes its way into Tennessee. Perhaps in those scenarios, it hasn't proceeded directly from the person because you have all of these intervening kind of, distribution
So it's like almost a
points.
proximate cause.
It's almost trying to
inquiry.
tie it to make sure it's tied directly to the defendant. I think that makes sense in terms of what we're thinking about, kind of the backdrop against which these statutes were enacted, which was the effects doctrine and kind of the concept that it's fair to hold someone to account in your state if they have kind of intentionally directed harmful effects, detrimental effects into that state. I think that this is kind of animating out of that principle, which is it's requiring a kind of directness to ensure that type of accountability and that type of, I guess,
So here,
protection.
the means that proceeded directly from this defendant were the acts of deception that induced the victim to transfer the money?
Yeah, I do think that those acts of deception, including the text and the emails, did proceed directly from the person. The statute kind of open-endedly just says if the person used. It doesn't really, I guess, tie the actual dispositive acts. It just says if they've used either an agent or other means. But I do think here that the deceptive acts that led to this theft, the text, the emails, the bill of sale that was signed by him, that did proceed directly from Mr. Lacy.
I know that your position is we don't really need to get to the common law doctrine here, but I am curious, I guess, which of our precedents do you rely on for our adoption of this detrimental effects test? I mean, I read our precedents as adopting more of a constructive presence kind of standard. Do you have, I guess, a case you can point to for our adoption of
Your Honor, I think,
maybe the more general common law standard that
yeah,
had applied in other
I think
states.
Watson is the best case for us. Now, Watson did happen in the context of aiding and abetting, so I don't think the court went as far as the 7 other state Supreme Courts have gone in Watson. But I do think that the reasoning of Watson and the animating that decision does kind of root in the same effects doctrine that we saw in Strassheim and that we see the other states adopting. Because Strassheim ultimately held that acts done outside a jurisdiction but intended to produce and producing detrimental effects within it justify a state in punishing the cause of harm as if he had been present at the effect. So the effects doctrine itself is kind of rooted in these constructive presence principles. That's the exact principles that we saw the court cite in Watson. The court in Watson actually cited to Simpson versus State. It's a state Supreme Court decision from Georgia. That's the same decision that Strassheim, the U.S. Supreme Court, cited. So it is like the paradigmatic kind of effects doctrine case. It is what the U.S. Supreme Court rooted its decision in, and this court not only cited it, it quoted it for the proposition that presence in the state, quote, need not be actual, it may be constructive. The court also specifically said that one may be entirely out of the jurisdiction of this court in another state and still be constructively present in the jurisdiction where the criminal transaction takes place. So we think the effects doctrine is rooted in kind of a constructive presence that is tied to the detrimental effects, and then we think that's exactly what this court was getting at in its Watson decision. But again, we don't think the court necessarily has to go there in this case. We think that the statute covers this case, but it could be important for other offenses, so we wanted to make sure that we raised it so that the court didn't unknowingly kind of foreclose other.
Raised it to make sure we avoid it, is that what you're saying, right?
Yes, Your Honor. Yes, Your Honor. Well, we haven't touched on sufficiency. If there are no questions on that, I will rest on the briefs, and I'm glad to answer any further questions, but I know this court has a busy day today, and so if there are no further questions, I'm glad to yield the rest of my time.
Thank you, Mr. Rice.
Thank you, Your Honor.
Your Honor, if I may, just a couple points on rebuttal. First, in regard to the state's contention that it is no defense clause of 3911-103 does not create a defense. It's our position that I don't think this requires the court to make some sort of logical leap to, circumnavigate a prohibition against reading in affirmative defenses. I think that territorial jurisdiction, as it's generally understood, would require the presence of the defendant within the state. And I think the legislature, in identifying the agent or other means proceeding directly from the person, is demonstrating an exception to that general rule that you have to have some sort of nexus with the state of Tennessee for the state to exercise territorial jurisdiction, over the defendant. I think it's a patent idea that if you're not in the state, there has to be some other reason that the state has territorial jurisdiction over you. Because I think the general case would be, for instance, this case was in Loudoun County. The defendant is a resident of Loudoun County, and all of his actions were undertaken in Loudoun County under that hypothetical. So the state doesn't necessarily have to prove any sort of connection with the state of Tennessee because it's evident and obvious. And in the case that a defendant's outside of the state, there has to be some sort of connection to the state in order for there to be territorial jurisdiction.
Well, but the jury determined that there was sufficient connections to the state of Tennessee, right? Right,
in this matter. But our position would be, and this leads me to the second one that I wanted to make, the language in the statute has remained the same since the 19th century, and I agree with the state that there was technology, not obviously the kind that we enjoy today that is even proceeding rapidly beyond what was involved in this case, but the legislature could have expanded the meaning of other means in 1989 and explicitly said by the use of electronic means, by the use of the telephone, by the use of mail, by the use of anything, and they removed the word any. That some point between the 19th century and 1989, they removed the word any to, in our opinion, limit the other means to the traditional understanding of being physical means. And while I have a brief amount of time remaining, I would like to touch on the effects doctrine briefly. It's our opinion that the state's reliance on the Watson opinion is misplaced. The Watson case is a case involving I believe, an embezzlement scandal where the defendant used an agent to accomplish that embezzlement in the state of Tennessee, and the this court explicitly said that the statute incorporated the action at issue in Watson, and its language stating that the effects, the language that states regardless of statute, it's our opinion that's not something that expands the statute, but is rather a reinforcement of the common law that the statute adopted. Because the language in Watson states that when it is the sort of offense that's of the character that's under consideration, which in Watson was embezzlement by means of an agent, that regardless of the statute, that he can be considered constructively present. And our position will be that is not an expansion of the common law or the statute, but rather a reinforcement of the statute's adoption of the common law.
Is there any indication in the statute, though, that that was, that the statute was intended to abrogate the common law, I guess to the extent it might have been narrower?
Not necessarily abrogating it, but I don't think that Watson is an expansion of the statute. I mean, it says regardless of statute, and it specifically contemplates a scenario that is encompassed by the statute. So I don't think it's saying that the statute doesn't cover this, so we're going to expand the common law to cover it. It's simply saying whether the statute covered it or not, the common law is sufficient for it. That's my reading of Watson. I have nothing further, Your Honor. May I be excused?
You may. Thank you very much. Thank you, counsel. We appreciate it very much.
All rise.